Sure, I'm Steve Shapiro. I'm the National Legal Director of the ACLU. Well, I mean, if you just talk about last term again, the 2012 term, where we were lucky enough to be co-counsel for Edie Windsor. I mean, that case was a thrill. I mean, everybody in the court felt like it was an historic moment. The case was argued by Robbie Kaplan, who's a partner at Paul Weiss. There was a sense, during the argument, that this was going pretty well, which buoyed people. We had the perfect client in Edie Windsor, and so all of that was a thrill. There are other times when you feel like you're really obviously swimming upstream, and that it's very hard to somehow penetrate. And for me, the biggest frustration over the last several decades has been the erection of a whole series of procedural obstacles that often make it very difficult for us even to reach the merits of the case. You bring a case because you want to reach the merits, you want a decision on the merits, and we very often find ourselves fighting on a different terrain, fighting on the question of whether or not the clients have standing, increasingly now whether the pleadings were sufficiently specific, or most commonly of all, whether the defendants, even if they violated your client's rights, are entitled to qualified immunity because the law was not clearly established. And so for me, I hate to lose. I want to win every case that we bring. I think we should win every case that we bring. But I feel the greatest sense of frustration when you just can't get past that first stage. I don't think it's a consequence of the professionalism of the bench. That's not my view on it. And I think we obviously, I agree with the Chief Justice that you want a group of highly intelligent, engaged, learned people on the bench. I disagree if what he is suggesting is that you can only obtain that result by going back to the same well over and over and over again. I think there is benefit from having a diverse set of life experiences on the court, and I define that very broadly. I think the fact that there are very few people on that court who have ever been trial judges or trial lawyers hurts the court as it tries to sort of understand how the judicial system operates. I think the fact that we now have 3 women on the court is terrific and makes it a very, very different court than it was when there was only Justice O'Connor, and I remember the days when there wasn't even Justice O'Connor. So I think that diverse experiences on the bench produce a better bench, and that we can and should strive for that without any sense that we're sacrificing quality in the process, because I don't believe that. I don't want to attribute motives to the court. There's an explanation for each one of those procedural barriers, and in isolation, I understand where they come from. But cumulatively, they've made it a lot harder for a lot of clients to get through the courthouse door, and have left a lot of claims that I think deserve to be adjudicated on the merits unadjudicated on the merits, and that seems to me unfortunate. Well, I think that I came to work at the ACLU, and Warren Burger was Chief Justice. So, but there were people here at the time who had been through the Warren Court. I never had the luxury of being a civil liberties and civil rights lawyer before the Warren Court, and so most of my career has been spent with courts that we would think of as relatively conservative, and I guess I'll say a couple of things. One is, for a long time, there really was this fear that kind of major landmarks of civil liberties and constitutional law were in jeopardy, and would fall. Whether that was Miranda, whether that was the exclusionary rule, whether that was Lemon v. Kurtzman, which is the Supreme Court's still default rule in Establishment Clause cases, Roe v. Wade, obviously, right? And interestingly, all of those precedents still sit. None of them have been formally reversed. The court has chipped away at the margins in various ways. But I would say the more significant thing that the court has done, as I said, was not to frontally attack those precedents, but to simply make it harder to assert rights under them by creating other barriers that limit your ability to press your case. The thing about the political affiliation of the court. The court was pretty political in the 30s. But I do think that there is a danger if the court is perceived to be another political institution in terms of its position in the American democratic process, right? Because the ultimate question of constitutional legitimacy always is who allows these 9 people to overrule the popular will as adopted by the legislature, and the answer is we don't live in a pure democracy in this country. We live in a constitutional democracy, and these judges have a different role and they perform a different function, and they do it differently than politicians, right? And if people stop thinking that they're not doing it differently from politicians, the court will suffer. I actually do think they do it differently than politicians. I don't think they approach their jobs the way a senator or congressperson approaches his or her job. But I think that what has happened over the years is that the nomination process and the vetting process have become so sophisticated and so comprehensive that by and large, presidents who appoint judges and Supreme Court justices have a pretty good idea of what it is that they're going to get at the end of that process. And I think the reporting on the Supreme Court has changed. Whether the reality of the Supreme Court has changed or the reporting has changed or both, I think is an interesting question. But again, when I first started doing this, you would rarely, I certainly can't remember, reporting on judicial decisions that would announce the political affiliation of the judges who, in the majority and the dissent. And now that's a routine part of reporting on the judicial branch at the Supreme Court and at lower courts as well, right? If not the political affiliation of the judge, the political affiliation of the governor or the president who nominated and appointed them. And on the one hand, I think that's an interesting, it's an interesting data point, and it often is predictive of outcome. Not always, but often can be predictive of outcome. On the other hand, I think it's something lost when we start thinking about the Supreme Court in those terms. I think it is better, and this is the way I try to talk about the court, just to talk about the merits of their decisions on the merits. One of the things that remains very impressive about all courts, but the Supreme Court especially, right, as opposed to the political branches of government, is that at the end of the day, they have to provide a written defense of their decision. And that defense is either going to be persuasive to people or unpersuasive to people. Right? And to me, we're better off focusing on the substance of that dispute than on whether the person who wrote it is a Republican or a Democrat. And yes, in broad brush terms, you can look at the Supreme Court and say there are certain justices that are more conservative and certain justices that are more liberal and certain justices that are originalists and certain justices that believe in a living constitution. And as generalities, that is helpful to a certain extent, but only to a certain extent. It's a much more complicated institution. I think they are much more complicated people. The process they go through is much more nuanced than that, and like all generalities, it breaks down, at various points, and you do wind up with unexpected alliances on unexpected issues, and so I think that the debate that we ought to be engaged in is not the question of where the 5 justices in the majority in Shelby County, Republican or Democrat, and what does that tell us, but who had the better argument here about whether or not this effort by Congress that had been reenacted, 4 or 5 times since 1965 to address ongoing voting discrimination, where the Congress had acted within its congressionally delegated powers. And people can dispute that. People obviously did dispute that. I think that dissent was more powerful and it was right. And that's where I think we ought to be, we ought not to be talking about labels. We ought to be talking about substance. Well, the court also often writes fractured opinions, and more frequently now than it used to. And John Roberts came in and said, I want more unanimous opinions. Haven't quite gotten that. He also said, I want more cases, and hasn't quite achieved that either. Courts used to be dissents used to be much less common than they are today. And one of the things about other legal systems, I digress here for a moment, but it is interesting. There are other legal systems whose highest courts do not permit dissents. They're like juries. And then the notion is, the cultural idea is, the law can only mean one thing, and your job is to tell us what it means, and you have to just keep banging heads until you figure it out. We have a different system, and I think we gain, because you don't get compromise verdicts in quite the same way, right? And then the dissents sometimes become majorities later in time. But when you have fractured decisions like the school prayer case, there's a certain amount of nose counting to try to figure out, well, what exactly it means, and what's the least common denominator, and what's the holding of the case, and what's the dictum in the case. But that's not, to me, the most interesting thing about the school prayer case, Town of Greece case, which I found very disappointing. We had filed a brief in that case. We were on the other side. But what I find disappointing in the case is I really believe that the majority underestimated the impact on a religious minority when you're sitting in a room and you're asked to observe, at the very least, a prayer that belongs to the majority religion, which you don't share, and your choices are either to remain silent when everybody else is praying, or get up and walk out in the face of your neighbors. I think that's a very sort of powerful a message of exclusion that is sent to minority members of the community, in this case minority faiths, that the Constitution was designed to protect us against that sort of religious division. And I read the majority opinion and I thought to myself, somehow or another, that didn't get through to the court. And so as a litigant, I think to myself, well, what do we have to do the next time to try to make the court understand what this experience is like from the perspective of an outsider, somebody who it might already be, for other reasons, marginalized within the community. Because one of the reasons that we have a Bill of Rights, of course, is to place limits on the power of the majority, to exclude the minority, and to do that, not to use President Obama's term, but I will, requires some ability to put yourself in the position of that excluded minority. And I think that the burden on those of us who litigate in the court is to get that message through. Is to get that message through. And so if you're thinking about amicus briefs, for example, to the Supreme Court, it's not clear the Supreme Court needs another amicus brief on Establishment Clause doctrine. But maybe an amicus brief somehow trying to tell that story, you know, in a way that resonates at a human level with the members of the court, can be a powerful thing to do. Well, you know, we take as part of our mission the responsibility of trying to help people understand the Constitution and our constitutional tradition and what it means and why it's important. You know, we're one messenger. We can reach only so many people. We're constantly trying to figure out ways to expand our audience. But I'm with Sandra Day O'Connor here. I think one of the real problems we have in the United States now is a lack of civic education and a lack of understanding, even among very highly educated people, of what this document means, what the Constitution means, why we have it, how it applies, what rights it protects, and why it protects them. And I think that it's much easier to lose your rights when you don't even understand them, and we all need to do a better job in helping people to understand what their rights are.